Good evening to everyone present here. A warm welcome to the demonstration Moot 2025. Congratulations on coming to GLC. As part of the orientation, we have organized a demonstration Moot to provide you with first-hand experience of Moot court proceedings. The purpose of this demonstration Moot is to give all of you an opportunity to observe how a Moot court proceeding is conducted. Today's round will feature arguments on behalf of both sides of the Moot proposition that has already been circulated to you. We hope this exercise helps you develop a clear understanding of mooting, and we will be elaborating on the process in detail during the orientation session that follows. Presiding over today's round of oral arguments is a distinguished division bench comprising of our esteemed alumni, Ms. Vyoma Joshi and Ms. Ira Gosavi. Ms. Joshi is currently an associate at Crawford Bailey & Co., while Ms. Gosavi is an associate at Khurana & Co. Ms. Joshi is a highly accomplished mooter. Her consistent success includes being a semi-finalist in both the Pro Mooters Mono Advocacy Moot and the second SMP Nirmala Devi Bam International Moot Court competition. Apart from being an avid mooter, ma'am is also a gold medalist at the Judgment Deliberation Competition of 2019 and the second runner-up at the National Judgment Deliberation Competition of 2020. Ms. Gosavi's staggering mooting achievements consist of reaching the quarterfinals at the World Rounds of the FDI International Arbitration Moot 2021, where her team ranked 7th globally. She was also a coach for the 2023 winners of the World Rounds. Beyond mooting, her debating prowess is seen in being part of the only team from India to qualify for the World Universities Debating Championship in 2021. They have also judged several memorial and oral round of prestigious moot court competition, including those organized by MCA GLC. They have always extended the support to mooting activities at the Government Law College. Our mooters for today are Mr. Khurana, appearing as counsel for the Petitioner, and Ms. Disha Sonawane, appearing as counsel for the Respondent. They are both fourth-year students of the 5-year law course at Government Law College and are amongst the most accomplished mooters of our institution. They have participated in several prestigious national and international moot court competitions, such as the Oxford Prize Media Law Moot Court Competition and the NLUO Bose and Mitra International Maritime Arbitration Moot Court Competition, and have secured top positions in multiple intra-college moots and other moot court competitions. The demonstration moot may start now. Thank you.
Please, my lords, I am going to petition against it. Before I proceed with my submissions, allow me to put forth a summary of the facts of the dispute before the court. My lords, the petitioner is an entrepreneur who has set up a factory at the request of the respondent state. The respondent approached the petitioner to set up this factory. The purpose of this factory is for the processing of the ore of this metal called vibranium. The respondent state the purpose behind starting or approaching the petitioner to set up this plant was because the respondent state was to exploit this element known as spice, which is formed as a byproduct of the process of my apologies. The respondent approached the petitioner because they wanted to exploit this element known as spice, which was formed as a byproduct of the process of extracting the ore of vibranium. The process of extraction would lead to this residue known as leach residue, which was a radioactive substance, which would then be processed further by the Ministry of Spice of the respondent state, which would then be used to
My apologies, my lords. May it please my lords, I appear for the petitioner in the instant matter. I will be addressing your lordship on the merits of the dispute. So allow me to put forth a summary of the facts before your lordship. My lords, the matter before your lordships today, the petitioner is an entrepreneur who was approached by the state to set up a factory for the process of extracting this metal called vibranium from its ore. The reason that the respondent state approached the petitioner is because the respondent state seeks to exploit this element by the name of spice, from which forms as a byproduct of the process of extraction of vibranium ore. What happens is, when this vibranium ore is extracted, a residue is formed by the name of leach residue, which is a radioactive substance, which is then further processed by the Ministry of Spice in order to get the spice element. The spice element is, my lords, an element that is used for cosmic travel, which is why the respondents have approached the petitioner in the first place. Now, my lords, due to the radioactive nature of the leach residue, which forms as a result of, or which forms as a byproduct of the extraction of vibranium ore, the Ministry of Spice is the only ministry, or is the only body that has the power to dispose of the leach residue. Now, my lords, once the respondent state approached the petitioner, the petitioner and respondent entered into an agreement by the name of the offtake agreement, wherein the respondent agreed, the Ministry of Spice agreed to dispose of any leach that was formed as a result of the vibranium of the process. This offtake agreement provided for 2 years of the term of the contract, with to be renewed by mutual consent. This, my lord, continued for a period of 10 years, with the agreement being renewed every single occasion without any hiccups. My lords, now the agreement was to expire, wherein when the petitioner approached the respondent to renew the agreement again. On this occasion, however, the respondent refused to renew the offtake agreement, citing a change in policy and stating that this method of extraction of spice was expensive and burdensome. It is pertinent to note that at this point in time, there was no hearing that was given to the petitioner. This was a decision that was simply communicated when the petitioner approached the respondent seeking renewal. My lords, now that I have given to my lords a summary of the facts, may I proceed with my arguments? My lords, insofar as before I proceed, allow me to put forth a caveat. I am well aware, the petitioner is well aware of the fact that the agreement contemplated renewal every 2 years, and that this was not a contract that was to extend into perpetuity. However, our entire arguments before your lordships are with the aim of convincing my lords that this agreement is to be renewed for another leg of 2 years due to the conduct of the respondent. My lords, the first issue deals with whether the petitioner had a legitimate expectation under Article 14 of the Constitution for renewal of the offtake agreement. Insofar as this argument is concerned, my lords, I have a two-pronged submission, stating that firstly, Article 14 applies to all state actions, even when it comes to contracts with private parties. Secondly, legitimate expectation can be inferred or can be found based on the facts and circumstances of the case in the present dispute. My lords, as regards my first prong, our submission is that even though the state has entered into an agreement with a private party, the state is still bound by the rigors of the Constitution. Article 14 would no longer be considered inapplicable simply because there is an agreement between the respondent's state and a party. The Constitution is the requirements of Article 14, and any contractual obligations are therefore not alien to each other. My lords, insofar as this is concerned, I am relying upon the judgment of Sri Lekha Kumari Vidyarthi versus the state of Uttar Pradesh, wherein it was stated, and I quote, "It is a different matter that in the scope of judicial review, in respect of disputes falling within the domain of contractual obligations, may be more limited, and in doubtful cases, the parties may be relegated to adjudication of their rights by resort to remedies provided for adjudication of purely contractual disputes. However, to the extent challenges made on the ground of violation of Article 14, by alleging that the impugned act is arbitrary, unfair, or unreasonable, the fact that the dispute also falls within the domain of contractual obligations would not relieve the state of its obligation to comply with the requirements of Article 14. Therefore, my lords, it is settled law that even though the interaction between the parties are also governed by the contract that was entered, the state is still bound to act in a manner that is just, fair, and arbitrary.
Am I audible now? So, what is the threshold of arbitrary unfairness and unreasonableness that has to be met in order to prove a violation of Article 14?
My lords, Article 14, which in strict terms denotes a right to equality, states, the jurisprudence around this article states that any action that is made by the state that is arbitrary or is unfair or unjust is violative of the right to equality. Therefore, if there is any state action that does not comply with its requirements under my lords, apologies, if there is any action by the state which is not in consonance with the terms of the constitution or the requirement.
I completely understand your point, right? But if that were true, that would mean that any contract that is entered into by private parties, wherein there is a meeting of minds, that is your consensus addendum that is happening while you're entering into a contract, would effectively be rendered useless because there is some sort of a constitutional overarching constitutional provision over it. What you need to prove before this court today is what is the threshold of arbitrariness and unfairness that is laid down under Article 14 that in the present instance is so grave that it meets that threshold and therefore you're claiming relief under Article 14.
Certainly, my lords. That actually brings me to my second prong of argument, wherein I will be taking my lords through the facts and circumstances of the present dispute to show to your lordships that there is in fact action taken by the state which is in violation of the petitioner's legitimate expectation. Now, again, as I stated at the very outset, the petitioner is aware that this is not a contract that was to extend into perpetuity. However, the conduct of the respondent has been such that there was a legitimate expectation created in the minds of the petitioner that his contract would be renewed for another set of 2 years. My lords, and I will take my lords through the facts and circumstances. The facts and circumstances both at the time of commencement of the contract and at the time wherein non-renewal was conveyed to the petitioner, both these facts and circumstances are of importance. My lords, firstly, taking in the time of commencement, the state was the body that approached the petitioner to set up this factory, giving the petitioner an assurance that they would dispose of any leach that was created through all the processes that the petitioner's factory would carry out. The state has a monopoly.
Can you point me towards the fact sheet as to where this is stated and make references accordingly?
My lord will see paragraph 3. The ministry proposed to Mr. Stark that he set up a plant for processing vibranium ore. The ministry assured Mr. Stark that it would pick up and dispose of the radioactive leach residue, which it would process to extract spice. So we have therefore a situation where the state is the party that has approached the petitioner to set up a factory. The state has a monopoly on the disposal of the waste that is to come out of this factory, meaning that the factory of the petitioner is functioning at the will and at the behest of the respondent. There is no third party that I could enter into an agreement with if this offtake agreement is not renewed. Meaning that the petitioner's factory or petitioner's processing plant would face closure. Traditionally, this agreement was renewed for 10 years, creating an established practice in the past. Moving on to the facts and circumstances at the time of non-renewal, or when non-renewal was conveyed to the petitioner.
I think you can take about. I think you can take another minutes for the rest.
I'm grateful, my lord. My lord, now insofar as non-renewal is concerned, the petitioner was only informed that his contract was not going to be renewed when he approached the respondent to seek renewal of this contract. At the time of non-renewal, there were no alternate sources of spice that were available. My lord will see paragraph 5. It reads, no hearing was given to the petitioner before this decision was taken. The ministry has since found other sources of spice which are not radioactive and contain on average about 10% of spice. Now, it's pertinent to note that at the time that non-renewal was conveyed to the petitioner, there were no alternate sources of spice available for which the state could exploit either. There was again no hearing that was given. Our submission in this regard is that the conduct of the state has been such that it would result in a legitimate expectation being created in the mind of the petitioner that his contract would be renewed for another 2 years.
This bench firmly believes that this is a commercial dispute and you have given it the garb of constitutionality to entertain this writ petition. That's why we are not inclined. If you want, you can arbitrate, mediate, negotiate the issue. It is a purely commercial dispute. Why go under the jurisdiction of a writ and waste this court's time?
My lord, with respect, of course we are highly cognizant and respectful of the court's time, but this is not simply a commercial dispute. In a situation such as this, where the petitioner simply has no other alternative and no other way in which his factory could be functioning, today the petitioner's factory functions only at the behest of the respondent, insofar as long as the respondent is willing to dispose of the leach residue that is created from my plant. Only till that point in time could my factory be functioning. And then, even if it is considered that the policy or this decision is something that is purely commercial, the fact that the petitioner was not given an opportunity to be heard before the termination or the non-renewal of this contract is further violative of Article 14. And I will be addressing my lords on that insofar as issue 3 is concerned, if I may just.
Under what article are you seeking remedy before this court?
226 of the Constitution.
Okay, so why don't you establish the maintainability before this court first, and then you move on to the rest of your issues. The other thing is that, was there any other clause in the contract that suggested any sort of notice or dispute resolution mechanism that you could adopt had there been a breach of contract?
No, my lords, there is no details regarding there having been another alternative dispute resolution or any other such clause. Insofar as the maintainability before your lordships, my answer would be twofold. Firstly, I have firstly contended that there is a violation of my right, of my legitimate expectation, which is a right granted to me under Article 14. A violation of a fundamental right is grounds to approach your lordships under Article 226. Even if my lords are not with me insofar as legitimate expectation is concerned, there has been a violation of the principles of natural justice insofar as the petitioner has not been heard before this decision was taken by the ministry of non-renewal of his contract. A violation of natural justice is certainly grounds to approach your lordships under the Article 226 of the Constitution. May I now move on to my third issue? Insofar as the third issue is concerned, I have a two-pronged submission. Firstly, any administrative decisions which would have civil consequences would have to be in consonance with the principles of natural justice. My second prong is that even when a hearing would not have the effect of changing the decision of the respondent, of the state, even then the right to the petitioner's right to be heard cannot be dispensed with. Firstly, it is settled now that principles of natural justice entail the right of an individual to be heard before he faces what are known as civil consequences. Civil consequences, my lords, have been defined in, for example, D.K. Yadav versus JMA Industries, wherein it was stated, and I quote, "It is a fundamental rule of law that no decision must be taken which will affect the right of any person without first being informed of the case and giving him an opportunity of putting forward his or her case. An order involving civil consequences must be made consistently with the rules of natural justice. Civil consequences cover infractions of not merely property or personal right, but of civil liberties, material deprivations, and non-pecuniary damages. In a scenario such as this, my lords, where we are claiming that our fundamental rights have been violated, with respect, I feel it cannot be contended that there have been no civil consequences towards the petitioner at the very least. If there are civil consequences, therefore it is necessary for the petitioner to be heard before any decision is taken against him. Secondly, insofar as my second prong, which was that even when the hearing would not have the effect of changing the decision, the right to hearing cannot be dispensed with. I would like to rely upon the judgment of S.L. Kapoor of the Supreme Court, wherein it was stated, "In our view, the principles of natural justice know of no exclusionary rule, dependent on whether it would have made any difference if natural justice had been observed. Therefore, it cannot be contended by the respondents that even if I was heard, their decision would not have changed, which is why they did not hear me in the first place." That, my lords, brings an end to my submissions. I'm grateful, my lords.
Am I audible? Thank you. Am I audible to everyone in the back? Thank you so much. Good evening, your ladyships. I am counsel appearing on behalf of the respondent in the incident matter, and I shall be representing the state of Wakanda in the present writ petition before this honorable court. Your ladyship, I shall begin my submissions and firstly address the first issue that has been framed by this court, which is pertaining to whether there is a legitimate expectation that a petitioner has so as to the renewal of the offtake agreement. Your ladyship, for an expectation to be legitimate under Article 14 of the Constitution, it must be reasonable and logical expectation based on an express promise or a continued past practice from a public authority. Further, only those legitimate expectations based on clear, unambiguous, consistent representations by a public authority are those that can be protected by a court or any other judicial authority. Further, such legitimate expectation is not a legal right, but only a means for a petitioner to challenge an alleged adversary or arbitrary order or decision that might be taken by an instrumentality of the state. In the case of the state of Jharkhand versus Brahmaputra Metallics, the Supreme Court categorically held that denial of a legitimate expectation can only take place when there is a breach of the right of the petitioner under Article 14 of the Constitution. So this goes on to establish that the two aren't distinct but are in consonance with one another. Your ladyship, it is the contentions of the state that there is no legitimate expectation that the petitioner has here, and neither is the petitioner able to satisfy this court that such legitimate expectation extends to his right being violated under Article 14 of the Constitution. I would be
beginning my submissions by proving to the court how there is an absence of a legal obligation and there is a contradiction to the express contractual terms as under the offtake agreement. Your Ladyship, it is the respondent's position, and as can be gathered by the facts of the case, that there is no legal obligation on the state to continue the renewal as under the contract for any period of time whatsoever. As under, my apologies. It can be clearly evidenced by paragraph 4 of the Moot proposition that the offtake agreement was only for a period of 2 years, subject to renewable by mutual consent of both the parties. Now, Your Lordships, the Supreme Court in the case of State of Bihar versus Dr. Sachindra Narayan has categorically said that unless a legal obligation exists, there cannot be a legitimate expectation. Further, I would like to state that this purported idea of the petitioner that he is rightly vested with a legal obligation of renewal is prima facie invalid. Further, the clause requiring mutual consent as under the offtake agreement negates the idea of any unilateral legitimate expectation that the petitioner might have here. And that too flowing from the petitioner's expectation of his understanding. His case is based on his understanding of what a commercial contract might be. In no way is this related to him seeking a remedy from this court under a constitutional issue. Further, as given by the Supreme Court in the case of Union of India versus International Trading Co., legitimate expectations cannot override express contractual terms or fetter the government's discretion when it comes to policy making. Your Ladyship, further, my apologies. Your Ladyship, therefore, the case that the respondent here is trying to make is that one cannot claim an exception to explicit contractual terms, and therefore the petitioner cannot reasonably state that he has a right of legitimate expectation.
I think that the petitioner relied on a case law to prove that legitimate expectations also extend to private contracts.
Yes.
How would you dispute that?
Your Ladyship, thank you for the question. I agree that while this is a contract that has been entered into by the state with a private party, the legitimate expectation, what our case is, must A, flow from a legal obligation that might have, and here in the present facts, his case of having had a legitimate expectation is in itself contradictory to the express terms of the contract. How can the petitioner have an expectation based on facts which are not in line with the express terms of the contract?
But by that, you are only going by the letter of the contract and not the conduct that has been followed for the past 10 years, I believe, between
Yes, Your Ladyship.
the petitioner as well as the state, right? So, if you see through conduct, it is very clear that this has been mutually renewed for 2 years.
Yes.
Past sort of 10 years.
Yes.
So, I don't think the case of the petitioner today is that, or they have a poor reading of the contract itself. The case is that going above and beyond the letter of the contract, through conduct it can be established that there is a legitimate expectation. I think the principle of the legitimate expectations doctrine is that it's an expectation and it goes beyond what's written down somewhere, right? So how would you sort of argue against that?
Oh, thank you for that question, Your Ladyship. I understand your point. What I would like to put forth before this court is that while we agree that the contract had been renewed 5 times over the course of 10 years, that does not inflict any sort of condition on the state to renew it for the 6th time. Further, over the course of these 10 years is when the state has realized that this process of having to deal with the leach residue, which is highly radioactive in nature, the state has to store it within their depositories for a period of 200 years before it can be disposed of. So over time, the state has realized that this entire practice is overburdening, it is expensive, and it is also creating a very valid health concern since the substance is highly radioactive in its nature. Further, for carrying out this practice, it is the taxpayers' money that the state is putting. So not only is this decision taken in the furtherance of a public interest, it's also being done with an idea of having financial prudence in the actions of the state.
We understand that for the greater good and in the interest of public health, morality, the state has to take certain decisions. However, what about adequate compensation to all the employees, all the workers, the owner of the factory, which will permanently lose their job? Has the state gone into the aspect of equity and done anything in that regard?
Your ladyship, the Moot proposition remains silent on the same. However, the petitioner has the option to approach a court and file a suit and seek any sort of equity-related remedy that they might have. The state might be open to providing compensation for their employees or any sort of other pecuniary losses that might be faced by the petitioner, but a constitutional remedy is not something that we are in agreement with. Your ladyships, if I could move on to the second issue, which is pertaining to whether a judicial review of the action of the state, if the action of the state is amenable to a judicial review. Much obliged. Your ladyships, the state has already made good on the fact that its action of non-renewal of the agreement is based on good governance and public interest. However, we believe that the policy decision of the ministry does not invite any judicial review either. This is because the actions of the state are rooted in safeguarding their public interest, which is in furtherance of the state responsibility of protecting the interests of the citizens while also making cognizant and financially responsible decisions as a state. As previously established and as can be evidenced by the Moot proposition as well, the entire practice of dealing and disposing of with this radioactive substance is extremely expensive for the state. Further, in Federation of Railway Officers Association versus Union of India, the Supreme Court has categorically held that policy decisions of the government, especially in economic and administrative matters, are not open to judicial review under Article 226 or 32 unless the policy is arbitrary, mala fide, which is bad in faith, or in violation of statutory or constitutional provisions. Therefore, courts cannot substitute their views for that of the executive in matters of policy. So what I'm trying to put before this court is that this court has to decide on the legality of an action taken by the state, not on its merits. Further, your ladyships, it is also the state's position that policy making is a prerogative of the executive. So unless the petitioner demonstrates mala fide, unconstitutionality, violation of procedural matters, or any gross arbitrariness, none of which exist here, the ministry's decision stands beyond interference from this honorable court.
But I think the petitioners, no hearing was given to them before any such order was released by the state, right? So yes, state can undertake policy decisions. Situation where you have a contract in place, which requires you to take decisions by mutual consent, and on top of that you have to adhere to the principles of natural justice, odi alternam partem. How would you still argue that this is not maintainable before this court?
I am grateful for the question, your ladyship. Your ladyship, the principles of natural justice, namely odi alteram partem here, apply mainly when an administrative or quasi-judicial decision determines individual rights or liabilities. In the present matter, the ministry's decision was a broad policy shift applicable not just to the petitioner but any other individual who would have been in his place.
Can you point me towards the facts where this was a broad policy decision that was taken?
Your ladyships, while it has not been expressly explicated in the Moot proposition, the reasoning provided by the state to the petitioner is that their actions were taken based on a policy decision. So my inference of the same is that this is not a policy decision specifically applied in light of the petitioner's plant or in his investments in this contract, but a broad policy decision that would apply to anyone had they been in his place.
But I think currently the petitioner is the only one who has this contract in place with you, right? So you can't really say that it's applicable to everybody because it is only a petitioner since it is only the petitioner who is doing this sort of business with you right now. So I think to say that it broadly applies to everybody is a bit of a stretch, and I think you can move on with your arguments. Also, I think we can also give the respondent 5 extra minutes since we gave that to the petitioner.
Much obliged, Your Ladyship. Your Ladyship, to the question put forth by you, I understand that it is a reach of the state to make the argument that this policy would apply to anybody had they been in the position of the petitioner, if not him. But it is pertinent to note that the decision taken by the ministry was not to particularly create any impediment to the livelihood or the actions or the financial operations of the petitioner. It was a policy decision taken by the state in the interest of the public and for securing the state's own finances, which is what the state's primary interest should be as a governing body. Your Ladyship, further, without prejudice to any of my arguments, since the position adopted by the petitioner is that he has a legitimate expectation here under Article 14 of the Constitution, I would like to direct the court's attention to Punjab Communications Limited versus Union of India, where it was held that legitimate expectation gives right to a fair treatment and not necessarily to a hearing. Such fair treatment is already being given to the petitioner here because, like we said, we are not creating any impediment to the petitioner. It is only pecuniary loss or only commercial damages that are being faced by the petitioner here, and he very well has the opportunity to seek any remedy before a court for recovering those pecuniary damages faced by him. Your Ladyship, as we know, the heart of Article 14 is non-arbitrariness and fairness and not protection of private interests disguised as constitutional issues. So the basis of the petitioner's case in contractual expectation does not qualify as a legitimate expectation meeting the ingredients of that under Article 14 of the Constitution. Further, an unarbitrary and sound decision has been made by the ministry, as can be evidenced by the Moot proposition. Because had the ministry wanted to create an impediment to the petitioner, such arrangement would not have continued for a period of 10 years. It is due to realization that we have taken the policy decision to make amends, and another point that was made by the petitioner was that there was no alternative available at the time of us making such decision or deciding not to renew the contract with the petitioner. Your Ladyship, we put before this court that...
Was there any notices clause in this contract? Was there any notice given to the petitioner, any heads up given to the petitioner where they were given some period of time before this contract was terminated?
Your Ladyship, I am not aware of the same, as the Moot proposition remains silent on the same. But like we said, if that is the redress that the petitioner seeks, he can approach this honourable court or the respondent in a private capacity, and we will make arrangements and we will make amends to any losses that might be caused to him as the petitioner here.
But you understand the problem with that as well, right? Because if the petitioner was still to approach this court for damages or any pecuniary losses, it's still not like the amount of time that it would take to determine how many losses have been faced is not commensurate with the losses that they would actually faced monetarily, right? Plus, we know most courts, it is quite slow and it's a long drawn process, in the process of which the petitioners stand to lose more money, more employment for their workforces, etc. So even the alternative is not particularly great for a petitioner, right? So for a state to say that no, the petitioner should approach the same court but on different grounds, there has to be some basis for you to argue that.
Your Lordships, Your Ladyships, we believe that the petitioner is not such that he is in a condition that my action has completely kicked his livelihood and there is a kick to his stomach directly. He is one of the most successful entrepreneurs within the state, as can be evidenced by paragraph 3 of the Moot proposition. So whatever pecuniary losses are faced by the petitioner here, we are ready to compensate that. Further, the case made out by the petitioner is that there is some sort of a carrot dangling action that was carried out by the state, but that is clearly not the fact, that is clearly not what has happened. It was also a commercial interest that the petitioner had while he was entering into the contract with the state. The extraction of vibranium and the process of dealing with that ore is also what is bringing income to the petitioner. So it is not only me as the state who is benefiting out of this practice. The petitioner himself very much has a monetary interest, and he was aware of this at the time of entering into the contract. So it is not that my action is leaving him in such a state that he is left with no income, no other respite whatsoever. Your Ladyship, if I could continue, much obliged. I would like to sum up my arguments by putting forth before this court that the case made out of having a legitimate expectation does not satisfy the requirements of a violation under Article 14 of the Constitution. Further, I would like to invite the court to see that the action taken by the state is in the interest of the public, and it is one that is unarbitrary and sound in nature. Further, since the action taken by the respondent is not arbitrary or is not malified in nature, it does not invite any judicial interference by this court, and this court must exercise the principle of judicial restraint and trust that the ministry is aware of the decisions that it is carrying out when it comes to technical responsibilities that a ministry is entrusted with. With that, I would like to rest my case, Your Lordship. Much obliged.
My lord, for the purposes of rejoinder, I will of course be in principle I reiterate all my arguments that I have made previously. However, there is just one additional thing that I would like to point out after having heard my learned friend's arguments. Taking my case at its worst, which is that the decision taken by the ministry to no longer utilize vibranium ore as a method of getting spice, even if we assume that this ministerial decision was correct and is not amenable to judicial review, if we take that one step further and say that even the fact that they decided to terminate my contract or no longer renew my contract, even if that was a correct decision, what my learned friend has not been able to justify is that is the manner in which this decision was carried out. I ask myself this: if an individual sets up a factory purely at the request of the respondent state, and as pointed out my learned friend points out that I am one of the most successful entrepreneurs, and this shutting down will not affect my factory. Similarly, 2 years of income isn't going to change or break my life, essentially. But my point is that my learned friend has not been able to justify the manner in which her decision was taken. The fact that there was no hearing that was given to the petitioner is a dent that she is unable to
Like you have not been able to justify how this should be entertained under the jurisdiction of a writ.
If I may have a minute for a Sir Rejoinder, Your Ladyships, much obliged.
The demonstration has now concluded. I request everyone in the audience to kindly remain seated as we will shortly begin with the orientation session. The floor is now open to questions for the judges and participants. Any questions for the judges and participants?
A very smart batch because nobody has any questions. Everybody has understood what has happened. Now it's working. no questions really.
No, we can caveat this question and answer round by saying that I understand that for most of you, this is probably the first exposure that you have to a moot court, right? So maybe this is a little bit intimidating, I get it. But you don't have to ask questions on legal aspects or anything, because I don't think anybody is a legal expert over here. If you have general questions as well with respect to mooting, how you can start, anything in relation to public speaking, what's a good sort of starting point for you to have, how can you prep, ways in which you can go about participating in such moot court competitions, feel free to ask such questions as well. They don't have to be technical or related to the round that you just witnessed right now, because I understand that it is a little difficult to take a grasp of when you're just seeing it for the first time. So ask very generic, regular questions also. I think we'll be more than happy to answer.
My question is to you that do we have to be a part of moot court committee to participate in moot courts?
Hi. So I would request you to retain those questions to ask us.
It's not compulsory for you all to be a part of the MCA in order to participate in moot court competitions. That's open to everyone in college.
Hello, hi, your ladyships. So basically I wanted to ask the question regarding the moot exercise. So clearly you established that this is a commercial topic, and I saw the petitioner was trying to drive way to the constitutional one. So how can you as ladyships or any other, how it can be established if we are seeing that the petitioner is intentionally driving away from two very different, from commercial to constitutional, even after you saying it multiple times. So how can it be maybe established that that you need to stick to commercial arguments here? We will not, this is not a constitutional debate that we are having, even after specifically saying that in the moot exercise.
So, I'll tell you, in my limited experience so far in practicing in court, we do this very often. We will try to find ways and means, because we know if we go by way of a commercial, under the Commercial Courts Act, if I approach the City Civil or Bombay High Court, it will be a long drawn process. But if I go by way of a writ and pursue the court to give me justice under equity, by default, if I show that they forfeited my deposit amounts, etc., all of that, I will get remedy. So in practice, we do all means possible. But in a moot court, the first thing that you have to do is master your facts. Now, I was purposely trying to ask him questions because I knew that if he just goes on some limited grounds, I cannot accept that argument. He has to first make a case as to why the writ is maintainable. So that is first. But I'll tell you, in practice, in moots you will encounter judges constantly asking you questions just to get to the root of your argument. But in practice, I really do not abide by that practice. I think it's absolutely wrong. Judges should accept submissions of the petitioner, submission of the respondents, and then pass an order. Otherwise, you go into inquiry mode and you give the party an opportunity to correct their case, which is wrong. So in moots, we do it just to get at the root of your argument. Speaking of why I kept asking him and how you can make out a case like that, then you just say that we are approaching under equity because we are not compensated, or it was done in a manner that was not in agreement with the contract. Then you go into how public bodies are not supposed to stick to the rigors of the constitution and cannot act arbitrarily. So those are arguments that you can make. But of course, see, there are limited facts at hand. So there are only limited submissions that they themselves can make. But I hope I've answered your question. In reality also how it works out in court and in moot court competitions also.
Good evening. To the petitioners is, I read from the paragraph 4 of the proposition. It says that, am I audible without the mic?
No, you're not.
Okay, thank you. So I read from the 4th paragraph of the proposition, which says that the agreement was for a period of 2 years only to be renewed by mutual consent. And correct me if my interpretation is wrong, but to be renewed by mutual consent does not necessitate mutual consent or communication for that matter for discontinuing or terminating the contract. So how do you seek to establish that the discontinuation of the contract without communicating the intent to the petitioner was invalid?
So you also answered because you've prepared, but let's say if something like that was posed to me, then I would try to establish how in expectancy of that continuation, I have invested in equipments, I have invested in my workforce, I have invested in all kinds of means and measures that I can take to give you a renewed supply of the extraction. Exactly. So, but then promissory estoppel, you have to establish that they told you. There has to be an express. Here that was not the case. So I go under the garb of, I knew that it is going to be renewed. There was no indication from their end to tell me that, it's not going to be continued. And when I approached them, they just told me that they are not going to be continuing with it. So in fact, that is how it would play out. I know that the moot proposition is very limited to that extent.
Hello. So comes to the high courts, all the hello. So when it comes to real practice, all the judges in the high court and supreme courts are very keen on dismissing the writ petitions. So when it comes to the moot courts, is it difficult for the petitioner to prove his points? As in real practice, the judges are like, okay, he cannot establish his point very easily. So yes, we will dismiss the petition. So as you are sitting there at lordship, is there
We can hear you.
So, in moot court, is it difficult for the petitioner to prove his points, as majority of the judges have bias against the petitioner, as they are very keen on dismissing the petition right off? So, is it difficult for the petitioner to prove his case in moot courts?
So I don't practice in courts very often, and I think Vyoma will be able to give you a better idea on how it actually works in actual courts and whether this is even true that they dismiss writ petitions very easily. But see, you have to understand the point of a moot court competition, right? It is not to simulate the biases, etc. of a court, if there are any. It is just to give you an idea of how courts function, not even function rather, or how arguments can be put forth, and it is to give you a flavor of public speaking and just improving your analytical skills, etc. So more often than not, the way that moot propositions themselves are drafted is quite balanced in the way that both the respondent and the petitioner will have some easier points to prove and some difficult points to prove, but it is quite balanced in that way. And as judges of a competition, of course, it is our duty to take that into consideration and judge the participants fairly. So there is no inherent bias towards any side, because that's just how these problems are drafted.
So more often than not in a moot court competition, what is expected from the participants is that you master your facts, no matter how limited they are. You have to ensure that you know everything about them. You cannot offer inferences that cannot likely be made from the facts of the case. You do your research in that regard, and then you very briefly put forth your submissions in a way that explain how the facts at hand are bolstered by what the law says. So in that case, you just try to pursue the judge to let them know that, hey, these are the facts. These points are favoring me. These are the points in the facts that go against the other party. This is what the law says, and that is why I am entitled to this relief or this remedy. It's as simple as that. But be rest assured that in real courts, that doesn't pan out that way. But in moots, that is all that is expected of you. And I think Ira would be in a better position to tell you, more about moots because she has won at international levels. So I have to really say that you all are very lucky to get this experience to actually ask her questions. Ask her about her mooting experience as well, how she got so good at it.
I've only done moots, I've not ever appeared in a real court like Vyoma has. And it's all fake.
We will be taking one last question.
Hello, am I audible? Good evening. I just wanted to ask, how do you prepare for the arguments, like finding the relevant cases or the case laws, the articles, and how do you prepare a perfect argument so that there aren't any loopholes while you're actually presenting them?
So I can take this one, but I think your participants should also chip in because they have prepared for this particular moot very well. So this is preparing for a moot is a bit of a long drawn process, right? It is essentially a case study that has been given to you. And I think as Vyoma very correctly pointed out before, you have to know your facts. That's step number one, okay? So you need to know in and out of your facts, where every single paragraph is, what it means, why it's there. Every word is going to carry some importance in that limited set of facts that you have, right? The second thing, of course, that you do is you do your regular research. I'm sure you all must have done research in some way, right? Like when you were in school before, or for your projects or things like that, right? So just like you would do that, go on Google things, figure things out, and then of course you have your legal tools. You have Manupatra, SCC for arbitration, you have Clover or various other platforms wherein you can sort of first from a starting point get a direction and then move on into figuring out case laws. You can look at commentaries, etc. right? So you go about your research process. Now with respect to arguments, right? So if you look at moot propositions, they will have the issues framed out for you. So the issues that both of these parties put down first, maintainability under Article 26 or legitimate expectations. These are issues that are already given in the moot proposition. I just want to ask, have you shared the proposition with them? Okay, so I think most of you have had a copy of the proposition. I don't know how many of you all have read it, but your issues are framed there, right? So then you go on to try and figure what your arguments are going to be. So the way to go about your arguments that I like to do is you have your issue first, you know what your issue is. The second thing you need to know is what is the threshold that you need to prove in order to prove your point, right? So in this particular case, I think the first thing they were trying to prove is legitimate expectations. So I would expect from both sides that you tell me what these legitimate expectations should look like from your perspective. What is the standard it is that you have to meet? Once you lay down your standard, then maybe if you have a case law which bolsters your argument, you can do that. But then you use your facts to meet that standard and tell me how is it that the present facts are meeting that particular standard. So that's how you have one argument in place, right? So you have three things to do, easy. First you have your issue, then you have your threshold, and then you have your reasoning, right? And then of course you have your conclusion. I think in fancy mooting terminology it's called IRAC, but it's just very logical. You can just think of it as a 3-4 step process, and then you have a conclusion in that case, right? So very easy, you follow, you break it down for every argument in this way, and I think that is very easy. The other thing that I think is very helpful when you're preparing, and it's very similar to any research project, etc., that you might be doing, is preempt what the other side is going to come up with. So once you have preempted what they will do, then you will put in more effort naturally to solidify your own argument a lot more, right? Because you know what your weak points are going to be and what the other side is going to hit you with. So if you follow like these few steps, I think it's a good starting point for you to have arguments in place.
And I think that adding to what Ira said, you will find that after doing all of this, when it comes to the actual mood, it's the speakers you would presume take up the limelight because they are submitting, they are presenting your case. But being a researcher of a mooting team is also very important. Their participation is also tested during oral rounds. You're allowed to pass chits in most competitions. So you being the researcher doesn't mean that you're only involved in the drafting of the moot proposition, and then when it comes to the actual competition, you take a back seat. There are researchers' tests that are taken in moot court competitions where they'll ask you questions on law and facts for that particular moot proposition. And you will have to, basically most of the time it's MCQ, so that is where your role is required. Secondly, during oral rounds, you can pass chits if you feel like your speakers are not, answering relevant questions in the best manner possible. So all that also is important. Secondly, I think it's very important to present your case well. I think there's no substitute for hard work, but I think court craft is also very important, because whether it be in real life or in a moot court competition, there's only so much that a person's attention span will allow. And if you don't catch hold of their attention, no matter how good your research is, no matter how good your case is, it is not going to fly through. So it's better to make sure that you're articulating it well. It takes time, it takes a lot of rehearsal. Do mock test rounds with your friends. Do it with your colleagues, do it with MCA, keep them busy, do all of that because you have those resources available. But ensure that you are learning also not just to research well, but also to present your case well, because that also holds a lot of water in any moot court competition.
Do you all have feedback? Does anybody have feedback for this, for our speakers? We would love to hear that as well. Anything you thought, any arguments you came up with and you thought that could be advanced on either side? Maybe they weren't because of a lack of time, or some question that you thought was unanswered and you have thoughts on how it could be answered. I think this is an open forum. I think we learn best from discussion. And I think it's a great thing that MCA is facilitating this. Otherwise you end up preparing for all these competition in a vacuum and you never understand what's the starting point of these things. So feel free to chip in. You have the advantage of knowing the proposition and hearing the arguments. So this is a good forum for you to spitball and figure out if your thought process is correct, or if things could have been done differently. So any thoughts also, please chip in. Feel free to chip in.
Hello. So firstly, it was a great experience to witness this very, very nuanced debate. I had gone through the note on arguments, and I did not think that it could go beyond that, but it was very great to see both the petitioner and the respondent. Also, like you mentioned, that there should be a hold on the facts of the case. So one thing that I noticed, the petitioner stating that the state has since discovered an alternative to the extraction from the vibranium ore. Is this a valid point? As per my inference, I believe that this could be a very great point to further solidify the stance that the conduct on the respondent's side was not justified. So what I felt, what I inferred was that this nuance that I had missed on my reading of the facts could further be elaborated on to justify that the respondent did not act as per the expectations, and there was
and could further solidify the petitioner's case. So could you please elaborate on if this is a valid point?
So, break your thought process down, right? You want to say that since what period of time was a new alternative found, like what is given in the fact sheet, like try and walk me through your thought process, right? What are you trying to tell me that because the petitioners have the respondents have after a certain period of time gone ahead and found another alternative, they're simply disposing of this contract with the petitioner now that they have a better alternative? Is that your thought process, or is there some other argument you want to make there?
So from what I inferred and has also been stated by the petitioner is that after the cancellation of the contract with the petitioner, after that there has been an alternative found to vibranium extraction.
Yeah.
Had there been an alternative found before the cancellation or the termination period of the contract, there would be, yes, a valid case and an expectation that the contract could come to an end.
Yeah, that's a good nuance. That's a great nuance that could have been picked up on as well. That's great. Yeah, you can definitely use that to bolster the argument that the legitimate expectation would have probably existed had this been found beforehand, and this was knowledge in the public domain, right? But the fact that it was discovered later and the contract was terminated beforehand, it was probably argued. That's a good pick. That's a good pick. Yeah. Anybody else? I think one last and then probably.
First of all, I want to say I am from first year at 5-year LLB course, and in first 2 years we are not introduced with laws, and I think in this orientation session this has not been cared.
No, I mean, I understand what you're saying, that it might be difficult for you to understand the application of law laid down, how to read a statute. But in today's day and age, we're all fortunate to live in the era of Google. So what I would suggest is that apart from taking mentorship from your seniors and the MCA, you can try and read articles on that particular subject. You realize that what the law actually says. Now bear in mind, and also when you start practicing, as lawyers, that these articles are written by journalists, not lawyers. So never take their word for it. Read the statute for yourself. Try to understand. If you don't understand, you always have commentaries. I often find in my research that I sometimes end up getting more material from commentary than a legal research, so like database like Manupatra or SEC. And then once you understand what the proposition says, once you understand what the statute says, and you understand what kind of cases you will require in your favor, then you go ahead and then you go on SEC, then you go on Manupatra, you search with certain keywords, and then it's very easy to basically get case laws that favor you. And it's very easy for you also as a law student who might not necessarily in the first 2 years be studying law to actually understand what the law says. Of course, law is very nuanced and it takes a lot of time to understand jurisprudence, application of law. But for starters, this will serve you just fine. So don't be intimidated by the fact that you don't know, law. It's okay. Even if you don't study it, by adopting these techniques, you can easily pass through and at least start practicing in moot court competitions. And also I have to make a point, it's called the practice of law, not the study of law, because when you study law, you really don't understand anything. It's only once you start practicing it that you understand it. So irrespective, even if you're studying it, be rest assured you're not going to be prepared for actually arguing in court or understanding law. That much I can tell you.
Any more questions? Seeing that there are no further questions.
Hello. I was saying that as a beginner, so when you're researching, how do you have an eye for
articles which would give you the most loophole-free arguments which one should present.
I don't think you will ever have an article which will not have a loophole in it.
Yeah, I mean, like, when you're researching and you're a beginner, so I'm just saying, like, how to distinguish that this is the one you should go for in your presentation and like that.
So I think one great point that Vyoma had made was that you come across an article, right? They will make references to certain laws, case laws, etc. Do the extra mile of going back and seeing what those are, because your articles are somebody's interpretation of what the law or what the case law is. You need the practice that you need to adopt is that you need to have your own interpretation of what those things are and a solid interpretation of that. So good way to go about it is to always use articles as a starting point and never your end goal. You use those as a starting point, look up those references. You will often see citations at the bottom or laws that are directly quoting from a certain statute. Go back, read what that law is, understand the bare language of it, read up on that case law, and form your own understanding of it. That's the only and the best way to go about whether you're doing it for a moot court, whether you're eventually out of law school and finally practicing as an advocate or anywhere else. That is the practice that is universally adopted. Right? So make it a habit to do that and use articles as a starting point. So you have your bar and bench or Mondac, all of these give you a good place to start from, but use that as a starting point always. Don't rely on it.
No, so how to not fall in the trap of not making a mistake of picking a wrong one, and then that will take your case in an entirely different direction.
Read as many articles as you can,
Okay.
and not rely on just one, right? So you know what your topic is. The goal should be to probably have read everything on Google that there is about it, right? And then you figure out what sources you want to rely on. Then you figure out what stance and approach you want to take, and what case laws and laws. See, because at the end of the day, when you're in a moot court, you are not going to quote an article. You have to quote the law, or you have to quote a case law, right? So, in order to get to the bottom and to find what the correct thing to sort of bank on is, read as much as you can. There is just no two ways about it, and I think that just continues when you start practicing anywhere or you become a lawyer eventually anyway.
Thank you.
Thank you for your questions. On behalf of the Moot Court Association, I would like to thank Ms. Vyoma Joshi and Ms. Ira Gosavi for consenting to judge the demonstration moot of 2025. I would also like to thank Mr. Khurana and Mr. Disha Sonawane for agreeing to participate in the demonstration moot.
Just some parting words, thank you to the Moot Court Association of GLC for actually putting in so much effort, organizing such a wonderful demonstration moot, always being there to answer queries of students. I know how difficult and rigorous it can be to constantly prepare, bench memorandums, reach out to lawyers to call them as judges, schedule so many online and offline moot rounds. So a big applause to the committee actually for bringing this into fruition. Now when I see my colleagues, and I'm sure Ira will agree to this, we realize that there was so much that I think other active forces in the college would do, whereas GLC it's mostly student run, right? Not to take away the efforts that the principal or the teachers do in our college, it's the students that actually keep all these traditions alive and put in so much effort to ensure that we have all the valid permissions, everything else is taken care of. So big applause to them. You all are very lucky that we know how difficult it can be to carry out these activities in our college with the way that things get done sometimes. And still to put in so much effort and do it day in, day out is a huge thing.
Yeah. I am very much in agreement with that sentiment.
Thank you so much for your kind words, ma'am. I request everyone in the audience to kindly remain seated as we will shortly begin with the orientation rounds.